So we'll start the deliberation. I know you'd have already covered the provisions, almost all the provisions relating with Sexual Harassment Act. You'll be knowing the provisions very well, and you'd have also heard about the implementation of the act. So what we can say about the Supreme Court view on the implementation of the act is that the Supreme Court is not at all satisfactory with the implementation of the act. So what we have heard in legislation about a decade after the implementation of the legislation, that is, the legislation came in 2013. In 2023, the Supreme Court delivered a judgment in its verdict in Aureliano Fernandez versus State of Goa. What court held was that this is inadequate. The existing system of implementation is inadequate because there is no adequate procedure, that is with respect to reporting of sexual behavior. There is no adequate provision for reporting of sexual behavior. That is, the victims or those who are subjected to sexual harassment are not at all aware of the provisions related with the reporting procedure, how to report, whom should they approach so as to get a, adequate relief. So that was the first reason. What court held was that there was an uncertainty about who to be approached for redressal of the grievances. We know that we will have to approach the internal complaints committee, isn't it? But most of the complainants are not aware of that. Who is the internal complaints committee? Who are the persons forming part of the internal complaints committee? So that was one issue that Supreme Court pointed out, that is uncertainty with regard to the body or the persons whom one should approach for reporting or for filing a complaint against sexual harassment at workplace. So that was the first issue. Second one was the lack of confidence in procedure. It was not at all transparent. It doesn't seem to be the members or the those who were in at the workplace doesn't seem it to be satisfactory. That is, they didn't consider it as transparent, and there was lack of confidence in the process and its outcome. So what were the processes that were involved in settling the dispute, and what would be its outcome? Regarding that also there was uncertainty. That in these two aspects there was uncertainty, and the court called it as a sorry state of affairs. Actually, court named it as, or expressed its anguish or its anxiety through the words sorry state of affairs. It was actually a sorry state of affairs. So we also know that it is actually a sorry state of affairs. So what is happening in the case of internal complaints committee for the persons who are forming part of the internal complaints committee? So what is seen nowadays is that we don't have adequate members in the internal complaints committee. So you know how should a committee be constituted, isn't it? It should have certain members with the aim of protecting women, preventing harassment against them, then for redressal of their grievances. So for that, there should be a chairperson who should be mostly a woman, a senior who is holding a senior most post, that is a woman at the senior most level. He should be the chairperson. She should be the chairperson. The other one is that there should be two other members. One should be well versed in social work or should have experience with the affairs of sexual harassment, or else she should have a legal knowledge, know-how about the affairs. So such a person should also be there. Thirdly, there should be an expert member from outside, mostly a person representing an NGO. Why should we have an NGO, an expert from outside? This to prevent bias, isn't it? This is an in-house complaint mechanism. So to prevent bias, there should be someone from outside. And so this particular member should be there, which is representing an NGO, non-government organization or association, or similar socially committed groups, persons from socially committed groups who are working in socially committed groups. So such a member is lacking mostly in most of the ICCs. If you go through the internal complaints committee, you can see that an NGO member is lacking. Most of the committees don't have an NGO member. Other one is there is a lack of members. They don't have enough members, chairperson and more than one half of the members should be women members. And we don't have, as I said, we don't have uh, uh, the adequate number of members. So the adequacy in regard to the number of members was also a problem. So all these were held out by the Supreme Court to be hindrances in the implementation of the act. So you know that it is 10 years after the implementation of the act. We know that internal complaints, internal committee, we now says it as internal committee after the amendment in the act in 2016. It is termed as internal committee, and the other one is local committee. Local committee means where the, as you know, that where the representatives or the woman is from an organized sector, say where she is working doesn't have more than 10 workers. If it is less than 10 workers, sorry, it doesn't have 10 workers. That is, it is less than 10 workers. If suppose the number of workers is less than 10, there is no provision for forming a committee there. If the number of workers is less than 10, we will have to go for, or we will have to come within the jurisdiction of the local complaints committee. We now call it as local committee, and the chairperson would be magistrate or additional magistrate or collector or deputy collector as nominated by the government. So that person will be the chairperson, and the other members should also be there. The persons representing NGOs, persons having legal expertise, then having social, those persons associated with social work, all this should be there. All these persons should be there. So actually we don't have such members with such expertise, and we also don't have adequate number of members in the committee. That is what is lacking. And you know that what is required in constituting is to protect the rights, to prevent women from sexual harassment. So to prevent women from sexual harassment is equally important when we say about the awareness of uh, the society in regard to the committee. Suppose if women members of the institution is lacking knowledge or don't have proper awareness about the constitution of a committee, that is also a problem. So all these are not addressed even after a decade since the implementation of the act. You know, the act came into existence in 9th December 2013, and now it's almost a decade, isn't it? Now it's 2013. It has passed a decade now. So when it passed a decade, nearly a decade, Supreme Court has promulgated its decision in Ori Liano Fernandez versus State of Goa. So what it held was that it's a duty of the employer to provide a safe and secure place for the woman to work. So what the court held was that otherwise they would be stepping out. They won't be interested. They won't be interested in continuing with the employment. So what is the obligation of the employer is to provide a safe and secure workplace, whether that is being provided by the employers now. So we know that it's not at all provided properly in the proper way as the act intended, isn't it? So we know that while however we worship or however we consider an act as great, it won't be adequate enough to protect the dignity of woman through giving her the adequate respect and giving her a means of livelihood. That is, she should be given a peaceful atmosphere. She should be given a safe, secure atmosphere to work. Otherwise, she won't be able to tap out her, tap out of her efforts through using her talents, skills. She won't be able to work peacefully. So she will even be wishing to step out of her job, because she is actually stepping out of fear, because she don't want to go against a supervisor. If I say supervisor or superior officer, if she doesn't want, or if she fears her existence is in danger, then she'll always be opting out to step out of the job. So that is what is the scenario now and what the court has addressed in Aureliano Fernandez versus State of Goa. So what court held in the case was that whatever procedure, the inquiry proceedings are mostly important. So it's a complex procedure. So it should be transparent. So whoever forms a committee, there should be what is the details regarding those persons forming the committee should be published, notified in the official website of the institution. So you know that all those who are forming part of the committee, the names and details of the persons should be published. That's notified in the official website. And also another one is second one is this is for the sake of, that is, this should be updated. All this details should be updated. Then another one is the second one, the other provision is that is if ICC do not have stipulated members, uh, then the institution should go for appointing adequate number of members in the internal complaints committee. Otherwise, it would be hard for them to function. So the first, as I said, the first requirement is that the union government, then the state governments, UTs, that is the union territories, all these have to undertake a time-bound exercise to verify as to whether all the public institutions have constituted a committee. You know that who is taking care of, who is collecting the data, who is collecting the information as to constitution of such committees. So what the government has to do first is to verify whether the IC or the internal committee has been formed in all institutions, including the informal sector. So that's the first thing that the court, that's the first directive that the court has given. Actually, court has given a number of directions. That's directives to be followed by the working institutions. Second one is it shall be ensured that all necessary information regarding the constitution of the committee has to be published, as I said earlier. Then the other one is similar exercise shall be undertaken by the statutory bodies of professionals at the apex level and state level with regard to other institutions. That is, you know that in regard to those regulating doctors, lawyers, architects, then company secretaries, then chartered accountants, of officials, all this. So this, all these bodies, statutory bodies of professional and apex level shall be instructed to form a committee. That is MCA, you know that Medical Council of India shall have to be instructed, then Bar Council of India has to be instructed, then All India Technical Education, All India Council for Technical Education has to be instructed, Engineers Council shall have to be instructed. So in spite of the bodies directly coming under the, what do you say, the union government, it shall also have to instruct the professional bodies as to formation of the committee. So that has to be done and steps have to be taken. The other one is immediate steps have to be taken by the authorities, management and employees to familiarize members of the committees with their duties. You know that even committee members are not aware of what they should do, how to conduct an interview, how to conduct an inquiry. Right from the time the committee receives a complaint, from the time of reception of the complaint, then when they go through the procedure of inquiry, and finally when they take a decision and submit their report, till then the procedure should be clear to them. So they should be made aware. So what the authority shall have to do, that is what the management or the employer shall have to do, is to give them adequate training on all these. So that was also directed by the Supreme Court in Aureliano Fernandez case. Then the other one is authorities, management and employees should conduct, employers, they should conduct orientation programs, workshops, then awareness programs in regard to these committees, so as to educate the women members of the organization, working women of the bodies. Suppose if they are not aware, then they won't be coming up with complaints. So all this, what do you say, the duties and responsibilities of the committees are to be made aware to the women members of the organization. So that was another thing that the court directed. Then another one is who can play a role in that. That is National Legal Service Authority. We have National Legal Service Authority. Then we have State Legal Service Authority. Then they should develop a module for conducting the awareness workshop. So they are they are professional enough, or they are proper bodies to develop a module how to conduct awareness programs. That members should be given awareness first. They should have to be updated about what is happening. There is a change in law that should be made aware to the members. At the same time, those who are working, the working members or the working employees, workers should also be made aware, particularly women workers. All of them should be made aware, particularly women members, because otherwise they won't be coming up with their complaints. That it's out of fear that they are always, what do you say, uh, uh, they are moving away from giving complaints. So they will have to be made bold enough to come up and give complaints. So what are the powers and duties they will have to be made aware of. So that's what the court has said. And for that, NALSA, National Legal Service Authority, State Legal Services Authority, all these can play a role, because they can develop modules with regard to what type of awareness programs should be provided to these people to make them aware, to make them bold enough to come up with complaints. Then another one is this should be included in their annual calendars. Because that we have National Judicial Academy, then we have State Judicial Academy. Then they can conduct orientation programs with regard to members, so as to facilitate capacity building in the members of Internal Complaints Committee and Local Complaints Committee, and also for making them aware of the standard operating procedures for conducting inquiries. That mostly inquiries are not conducted in a proper manner. So what is happening is that the court has also held that the due procedure should be followed in conducting inquiry. What has happened in Aureliano Fernandez case is that the particular person, the delinquent employee, was not given adequate opportunity to show cause against the offense that was, held to be committed by him. And that was suspected to be committed by him. So that has to be proved. So the defense, what he has to raise before the committee hasn't taken place, because he was not given adequate time or proper opportunity to represent his case before the committee. So that was what held by the Supreme Court in its final decision, that there should be a due procedure. That every man, whenever we deal with sexual harassment, we'll always go into Article 14, isn't it? So if we have, it is actually positive discrimination on the basis of sex, because we are following, actually we are implementing the legislation through Article 15(3) of the Constitution, because it is a special provision for the sake of women. So that can be implemented, because it is a form of affirmative action. So that can be done. So Supreme Court is always reading 14, 15 and 19(1)(g) together. 19(1)(g) says about the right to work. Right to work to be bold enough to raise complaints against superior officers. So all these provisions were read together by the Supreme Court in taking a final decision. That is Article 14, 15 and 19(1)(f). That every time we always see that Supreme Court respected affirmative action to the extent that those who are backward, considered as backward, should be brought to the forefront, and then law should be applied to them. And that is actually equality before law. First of all, we will have to make them, we'll have to bring them forward and place them at the same level with those who are enjoying equality fully. So we know that positive discrimination is allowed to a certain extent. So sexual harassment law is always welcome. So what we need to prove is that there should be Article 14, equality. Then there should be prohibition of discrimination only on the basis of sex. That is Article 15. But there is also another provision in Article 15 saying that special provision shall be made for women and children. So we can say that 14 is also is inconsistent with Article 14 and 15 of the Constitution. And also 19, which says that these people, that is, women should have a right to work, as in the case of his her co-part male co-worker. So along with a male co-worker, she should also have to work at a safe, secure place. That is, she should be provided with a safe, secure workplace. So that is not actually seen to be implemented through the legislation. So all these are inadequacies or loopholes existing in the legislation now. So what the court has suggested is for, what do you say, for making it enforceable. That is strict adherence to the enforcement regime under the Act. So whatever is there, we should be in strict adherence. We will have to implement the Act strictly in accordance with the provisions of the Act. So what has been held in the Act should be strictly implemented. So we'll have to see whether that is getting implemented or not. So all these bodies can play a role. Another one is, it shall be the duty of the officers, that is secretaries of ministries, Government of India, Chief Secretary of State, duty, etc., to see or to ensure that the implementation of the direction issued by the Supreme Court has taken place. So what has been suggested by the court is that the registry of Supreme Court is asked to send these directives or the judgment to the National Judicial Academy, then the Chairman Bar Council of India, then to the Registrar General of all high courts. From there, they should send it to the State Bar Council, because Bar Council of India can send it to all the bar councils, all state bar councils. Then the Registrar General of High Court can send it to all its subordinate courts, state subordinate courts. So it should reach everywhere. So Chairman Bar Council of India can transmit it to State Bar Council, and also to state level committees. You know that every professional body has state level committees. Under Medical Council of India also there are state committees. Under Engineering Council also have state committees. Banking sector also have state committees. So all these should be transmitted to the state level. That it should come down to the people to make them aware of what is there in the Act actually. So then only we can say that it has got properly implemented. So what is lacking actually is the proper implementation of the Act. You know that finally, Member Secretary Nalsa, he was asked to transmit copy of judgment to all state legal services authority. The National Legal Services Authority Member Secretary was asked to transmit it to the Member Secretaries of all state legal services authority, then to Registrar General of High Courts, and from where that should be transmitted to directors of State Judicial Academy, then the Principal District and Sessions Judge. So the judicial, that is from the Registrar General of High Court, that can be transmitted to the Principal District and Sessions Judge. And from NALSA, from State Legal Services Authority, that can be transmitted to the copy of judgment can be transmitted to State Judicial Academy. So it should reach everywhere. So people should be made aware of what is happening with the Internal Complaints Committee. So what has been identified by the court is that there's lack of members in the committee. It's not properly constituted. And even the mandatory member, that is the external member representing the NGO, is also not seen to be included in the committee. And another one is these people, that is particularly women workers, are not aware of the existence of the committee. So this should be published in their website, and it should be updated as well. Every time it should be updated. Then adequate training should be given to the workers, then as well as the members of the committees for making them known about the standard operating procedures in conducting the inquiry. So whenever inquiry is conducted, it should be properly be done, because you know that due procedure should be followed in conducting inquiry. So that was what identified by the Supreme Court in some other decisions. One is Union of India versus Surinder Singh. That is, due process has to be followed in conducting inquiry. That is a 2024 decision. Another one is Binu Tamta and another versus High Court of Delhi. It is also a 2023 Supreme Court decision. What was held was that this sexual harassment of women at the Supreme Court of India. You know that every organization is having their own sexual harassment regulations. You have UGC, you know that UGC is having prevention, prohibition, and redressal of sexual harassment regulation 2015. Then similarly, Supreme Court is also having a sexual harassment regulation, that is a prevention of sexual harassment, that is sexual harassment of women at the Supreme Court of India, prevention, prohibition, and redressal regulation 2013. So this was called for amendment because the appellant they claim that this should be amended so as to include LGBTQ community and men. Men should also be considered if like same-sex harassment has to be faced, then such people should also be included, like LGBTQ as well as the other sex, that is man. So what court held was that sexual harassment law came into being under Article 15.3 of the Constitution. You know that under Article 15.3, we can only make laws for the sake of protection of women. So we can't make any law for the sake of protection of men or any others like LGBTQ. So what has to be done is that the legislature should change it. Court cannot direct the legislature to make a law saying that an amendment should be made so as to include LGBTQ. So it is with the legislature to do that. The court is not the proper authority to direct the legislature to include or to make such and such amendment in the legislation. So first of all, the fact is that this is coming under Article 15.3. So it's only for the sake of protecting women. So we can't say that it should be used for the sake of protecting men. So that was what court held in Binu Tamta and another versus High Court of Delhi. So there are a number of such legislations that has such views that has been put forward by the Supreme Court. Another such decision is Anuj Garg versus Union of India. It is a 2008 decision. So the view of the Supreme Court was that, you know, that what has been held in Aureliano Fernandez case is seen reiterated. Actually, it has reviewed the working of the committee in Aureliano Fernandez. We know that there are two types of harassments. One is quid pro quo harassment. So something for something else, isn't it? So what we give and take. So what we desire, we will have to act according to that. So if you want to get some benefits, you'll have to act according to that. So is it that type of harassment, quid pro quo, that is acting for something in return? So that is what actually happening in certain instances of sexual harassment. Another one is creating a hostile working atmosphere. Actually, women can be made, insecure in a workplace. So there, what is created is a hostile working atmosphere. So a hostile working environment should be there, or either it can also be a quid pro quo type of harassment. So you know that hostile type of environment in the case of sexual harassment is actually a common law rule. So it's not in our legislation. It has come up from the principles of common law in UK. So there we have adopted, and from that we have adopted hostile working environment. If you can prove that a woman is subjected to sexual harassment, suppose there is no such instance as quid pro quo harassment, then we can say that there is an instance of hostile working environment harassment, out of harassment. A hostile working environment is created out of harassment. So that is an application of, actually, that's an application of common law principle. It's not the application of quid pro quo principle. But you know that in Visaga guidelines can be applied. Where in Visaga guideline, it has been adequately put forward by the court that a woman can be threatened. You know that in Act also, we can infer that hostile work environment can be inferred from the Act also. So the term as such is not mentioned. We know that by implication or by direct action, a person can be brought under threat to act in a certain way. Or a person can be, they can be made to act so as to mete out to them certain benefits. So if we wish for some benefits, we can act according to what our supervisor says. So these are two instances. Suppose we are under threat, we can say that a hostile environment is definitely created. It may be direct or it may be overt. It may be by implication only. It may be direct as well. So in both cases, we can say that there is the instance of hostile work environment. So in Anuj Garg versus Union of India, it was held that it is the duty of the state to ensure circumstances of safety. So if we can ensure safety, that would inspire confidence in women. That would make the woman more confident to work. So, and also we can say that they are also given the opportunity to follow in the profession they wish to they wish to choose. So whichever profession she wishes to follow, that can be provided to her if the state can ensure safe workplace. So what the state can do is to ensure circumstances of safety that can inspire confidence in women. So what is lacking is lack of confidentiality. So the woman is not confident to work in that work atmosphere. Also, the woman should be confident about the protection that she will definitely receive out of the provisions of that. So she should be made aware of the provisions of that. So she should be made more confident through making her aware of the provisions of that. At the same time, the state should also take steps to ensure safety at workplace. The state can take steps to ensure safety through collecting data. You know that in the case of local committee, there is no provision for collecting data or information or about the number of cases or complaints filed and number of complaints settled by the local committee. There is no provision for that. No one has studied or no data has been collected on that. But the state can ask for report. Prompt filing of reports can be asked from the part of the organizations. It doesn't matter it is private or public. In Vishaga guidelines, you can see that they specifically mentioned both private and public entities coming under the purview of that. You know that wherever women work in formal sectors, the woman can file a complaint under the Internal Complaints Committee. If she is working in an informal sector, she can uh, she can file a complaint in before the local committee. The local committee is chaired by a person appointed by the district collector, a prominent woman dignitary or a person involved in works of who is having experience in social work, who is involved or is interested in women's welfare, can be made the chairperson of the committee. So this can be made what do you say, the committees shall have to be constituted on time. Then adequate person should be there in the committee, and whatever the act says, the presence of like the presence of external expert, which is mandatory, that should be there in the committee. So if the state can take measures to ensure all this, the state can also ensure that there is safety in the workplace where women are working. That can inspire confidence in women, and she can also be allowed to continue in the workplace where she wishes to follow. So that is what has been held by the Supreme Court in Anuj Garg versus Union of India. And another one is regarding employment. Suppose in certain sectors, if women are not allowed to work, that is also demeaning or that is also lowering the self-esteem of women. That suppose, for instance, in Delhi, in one of the decisions by the Delhi High Court, it struck down Section 30 of the Punjab Excise Act 1914, where women were not allowed to work. Actually, under Section 30 of Punjab Excise Act, women were not to work in premises, any premises or any part of the premise in which liquor or other intoxicants are consumed by the public. So that was considered to be a bar for women to seek employment. So wherever liquor was in sale or in distribution or was served in such premises or parts of such premises, women were not allowed to work. So what is actually necessary is not a bar in the employment of women. It's not it won't end there. If suppose a woman is barred from the liquor industry fully, then that can put an end to sexual harassment. No, it is not the proper way that state should follow. What it has to do is that it has to take measures to ensure that there is no more sexual harassment in workplace. So that should be ensured first. It is not like putting a bar on employment of women. It should be in the manner of ensuring safe then workplace for women where she is secure and where she is given the inspiration to continue for her living. So the dignity of woman should be protected. So woman should be given respect. Unless and until woman is given the respect, woman is given the feeling that she is safe and secure in a workplace, she can continue or she can choose this job she is actually willing to continue with. So that is what should be done by the authorities. But actually, we are going for complete bar and all, like barring women from any employment related with liquor. So that should not be the case. So there, the High Court banned that particular provision. Supreme Court also, what to say, affirmed the decision of the High Court, and it held that this is prohibition of employment totally. So that is against Article 14, 15, and Article 21 of the 19(1)(f) of the Constitution. Because a woman is not allowed to, what to say, to undertake any job or to, what to say, take part in any business, trade, occupation. So that is actually curtailing her fundamental freedom. So that is actually curtailing her right to equality. It is actually prohibiting, or it's actually, what do you say, discriminating her on the basis of sex. That is Article 15. And it is actually a bar on a right to employment. That is coming under fundamental freedom to seek any employment, coming under Article 19(1) of, which is indirectly leading to Article 21. So all these aspects should be taken together. So it should be the removal of sexual harassment from the workplace and not barring women from certain types of employments. That is what the court held in Anuj Garg case. So that's a very important decision. Then another one is, that hostile work environment. So that was brought back through a decision, Apparel Export Promotion Council versus A.K. Chopra. So where it applied Vishaga guidelines. So through applying Vishaga guidelines, court held that the perpetrator's conduct led to intimidating hostile work environment. So it's a perpetrator who is creating a hostile work environment. So what it applied was the Vishaga guideline. So wherever there is no law, the court can apply the guideline, Vishaga guideline, or any directions that is there in the place of law, which is issued by the Supreme Court. We know that Article 141 gives us precedent, speaks about precedent. So wherever there is gap filling needed in the case of legislation, we can adapt to Article 141 of the Constitution. So you can seek the help of precedent. So here, hostile work environment is taken from Vishaga guidelines. So that is another view taken by the Supreme Court, that is Apparel Export Promotion Council versus A.K. Chopra. Then another decision is Srinivas Rajan, that is any agreed woman may make in writing a complaint of sexual harassment at workplace to the IC. If so constituted. If it is so constituted, the woman can file a complaint to the internal committee. Otherwise, she can file a complaint to the local committee in the case of informal sector. Then another one is, another case is in apparel transport. Any action or gesture outraging the modesty of woman must fall within the general concept of sexual harassment. So anything can be considered as anything that is held to be outraging the modesty of woman. So who will determine that? The court can determine, isn't it? That is any action or gesture, whether directly or by implication, aims at or has the tendency to outrage the modesty of woman or a female employee, must fall under the general concept of sexual harassment. When you say sexually colored remarks, what do you mean by that? Who will determine? That is, when we say sexually colored remarks, sexual harassment is defined. It can be physical contacts, it can be sexual demands, demand for sexual, for what do you say, sexually colored remarks, then demand for sexual favors. So what do you mean by sexually colored remark which is unwelcome? That is what is the court held. That is any type of behavior which is unwelcome, including sexually colored remarks. So who will determine the what do you say, the incident or the happening of sexually colored remarks? If you make a remark, who will be deciding that it is sexually colored remark? So there is no what do you say, adequate rule for determining sexually colored remark. What court can hold is that if it is unwelcome, it can hold it as sexually colored remark. So that was held in another judgment, which was by the Madras High Court. So it held that what the respondent employee did was that, the delinquent employee did was that, he abused his co-worker, female co-worker, calling her prostitute. So that was the audacity happened from his part. And he also slapped her in front of the other employees. So the court held that this conduct can never be condoned by the court. So the court took that into consideration and it considered as sexually colored remark for taking action upon the employee for sexual harassment. So it's for the court to take action. That is in management of Tamil Nadu Transport Corporation versus the presiding officer, Labor Court Salem. So Labor Court Salem that held that it didn't take it as a serious matter. It was held to be a what do you say, a petty matter, and so that could be what do you say, such an aspect should not be taken into consideration seriously. So that was what the Labor Court held. But the High Court, Madras High Court, held in the reverse. It held that such an act should be taken seriously. It amounts to sexually colored remarks. So a sexually colored remark means any remark that is amounting to sexual harassment. So that has to be decided by the court. So that is what happened here. Labor court didn't take it as a serious matter, and so it considered it as a trivial matter, and it didn't penalize the other employee for calling her prostitute or for slapping her. So it considered it as a very, what do you say, a trivial matter, very a matter of less importance. But Madras High Court held it as a matter of serious concern which ensues serious consequences, because that was a matter of sexual harassment. So that it held it to be a sexually colored remark, calling a coworker, because a coworker is a person who is standing at par with a male coworker. A female coworker is a person who is standing at the same level or who should be considered at par with the male coworker. So a person cannot call, or it's not legal, or it's not within the bounds of law to call a person as prostitute or to slap her in front of other employees. That is as such, that is actually, that is demeaning the woman's, what is a character, demeaning the woman's, that is lowering the woman's self-esteem, that is actually denying her self-respect, then respect and dignity in front of others, and actually denying her right to life. Right to live with dignity is a part of right to life. So whatever we do or whatever steps we take, we should apply the procedure of due procedure. The due procedure in accordance with law shall have to be applied. So if suppose a body is taking a criminal action and disciplinary proceedings are also going hand in hand, suppose a person gets acquitted in the criminal proceeding, when the criminal proceedings were over, the person got acquitted, whether that will affect the disciplinary proceedings? It won't affect, because disciplinary proceeding is entirely different. A man may not be a criminal as to convict him for a sentence, but convict him for a particular term of imprisonment. He may not be a criminal, but at the same time, he can be subjected to disciplinary proceedings. Suppose any of the incidents of sexual harassment is coming within that. So under service rules, if he is subjected to disciplinary proceedings and there is adequate proof, so the proof in criminal proceedings should be beyond reasonable doubt. So the other one is, in the case of disciplinary proceedings, we only consider the preponderance of probability. If it is probable that a man has committed an act of sexual harassment, then he can be punished. Its probability only is taken. So preponderance of probability is taken in the case of disciplinary proceedings, but in the case of criminal proceedings, it should go beyond reasonable doubt. So even though a person, worker or an employee is acquitted after the criminal proceedings, he got acquitted, that doesn't mean that he won't be subjected to disciplinary proceedings. He can be subjected to disciplinary proceedings. So that are generalizations which the court has reached, the Supreme Court has reached. Another one is that Supreme Court held that that's an important case, that is Sakshi versus Union of India, where Supreme Court held that it may not be in the interest of justice to permit cross-examine of the victim by the perpetrator. See, the internal committee can question the victim, but if suppose a victim is cross-examined, is made to cross-examine by the perpetrator, that won't be considered. That couldn't be considered as constitutional, or that wouldn't be considered as valid within the purview of the act, because it can be considered as valid if the IC is cross-examining the victim. It's okay if the victim is cross-examined by the IC, but if she is found cross-examined by the perpetrator, that cannot be allowed. So that is another aspect where we should have to pay respect to the dignity of woman. So that was held in Sakshi versus Union of India. Then another one is, instead of that, suppose if the other person, that is perpetrator, is cross-examined, that can be done to a certain level. But suppose,
sorry to
yes,
interrupt in between. We have a paucity of time. Our session is from 2 to 3, so it would be highly appreciated if you could draw to a
okay, then I'll conclude. If the
Thank you, sir.
respondent and defense witnesses are cross-examined elaborately, you know that respondent, perpetrator can be cross-examined. The defense witness can also be cross-examined. But if they are also examined elaborately, that can also be held to be invalid. So there should be some sort of, what do you say, balancing between all this to prove sexual harassment, to see whether sexual harassment is taking place. And actually, it is the right to work of woman that should be given more importance. So woman shall be made, or shall be given her right to work, shall be provided with a right to work. So for that, she should be given equality. For that, there should be anti-discrimination. There should not be discrimination. She should be given the right to live with dignity, which is a part of Article 21. And she should be given a right to work under Article 19(1)(f) of the Constitution. So with these words, I conclude. If you have any doubts, you can raise.